Okay, who would you like to call first?
If we can do Cano first. Sure.
What's the last name?
Cano.
Oh, Oscar Kano, 21 CF 360.
Brian Phelps for the state. Eric T. Lander on behalf of Mr. Cano, who is present.
And this is a motion to reduce bond.
That's correct, Your Honor.
Are both sides ready?
Yes, Your Honor.
Okay, go ahead, sir.
Thank you, Your Honor. First, by way of background, my client is 36 years of age. Prior to this case, he was an operations manager at Balco Manufacturing for over 16 years. As a result of his arrest on this case, he did lose that position. He was the sole supporter of his 17-year-old and 9-year-old children. His wife has since picked up some nursing shifts. However, he was the breadwinner and providing the family stable income before this event. Your Honor can see he does not have any other criminal history in the last 15 years, no convictions in his record. And Your Honor, since this case has been pending since 2021, he's had absolutely no issues with attending each and every court date, checking in with pretrial services. As a matter of fact, pretrial services, because he was so diligent in checking in each and every court date, has basically told him, don't bother anymore, just keep us posted if anything of substance comes of the case. Lastly, Your Honor, and I believe most importantly, is what's laid out in my motion, as since the bond that was posted by my client originally, it has been reduced, I believe once or twice, to allow Mr. Cano to pay attorney's fees and pay for the expert. Ongoing, as discovery was continuing to come in from the state, it was learned and it's been discovered through DNA evidence as well as accident reconstruction that it's the defense's belief that my client wasn't the operator of the motor vehicle on the day of the crash. I think that, Your Honor, coupled with his background, his diligence in checking in with pretrial, can assure the court that he will be compliant with any conditions Your Honor may set as a condition of his bond. Your Honor, I'd also ask that it be reduced because if the state is going to proceed against my client to trial, obviously there are going to be fees involved through my office as well as our expert to come in and testify for his defense. So, Your Honor, I think based on the length of the case, based on the history or lack thereof of my client, the fact that he's attended each and every court date, as well as the new evidence that has come to light in this case, I will be asking to reduce my client's bond from, I believe it's now at 150,000 with 10% to apply, to 10,000 with 10% to apply. So my client can further retain the expert for his defense as well as the counsel of his choosing. And I believe that is appropriate under the old statute, which he was originally granted bond from. Thank you.
Okay, Mr. Phelps.
Your Honor, at this time, it's a unique motion, Judge. The only reason I say that is because the defendant is already released. This is clearly not a motion to reduce bond in order to effectuate him being able to be released from custody. We've already heard multiple motions on defendant's motions to reduce bond. I know the last one was particularly, I believe, based on this issue as well, is that he needed money to basically retain an expert and make sure that they were paid. The only concern the state has at this point, Judge, is there's really no itemization or anything as to how much that expert is. And it's basically the same motion we've already heard, Judge. He has been appearing in court every court date, but he has posted bond. So the bond is doing its job and that he is appearing before court and following the rules. Every time we lower it, that's a risk that we take that he does not comply with those conditions or that it's not enough to secure his appearance in court. But the second issue, Judge, is again, we've already had this litigated, but it does raise another issue if he is not afforded that monetary relief to hire the expert, it becomes an issue then too. I don't know if the court could require any specificity as to how much of these payments are going to the expert. Obviously, counsel's fees can be paid out at the end of the trial if there's any bond remaining, but that should not be a reason just to reduce his bonds to pay for his attorney at this point. It should be used for the expert. So again, I would defer to the court and what proof that the court needs that where this money is going or what the bond is being used for, but I know, again, it's already been reduced twice, once for this exact purpose before, Judge. So we technically would leave it to the discretion of the court, but I guess we do have a general objection to continuing to raise this motion and to continue just giving the money, without any, sort of accounting as to where the money is going, if that makes sense.
So I see an order from October 11th of 23, it was reduced to 150,000, 10% to apply, which means he still has 15,000 posted, I would believe. And now you're asking me to reduce it down to 10,000, 10% to apply, so only has $1,000 posted?
That's correct, Your Honor, and if I could just briefly respond to the
Sure.
state's argument. I believe the facts are different, in this case, hearing this motion now, as it was back in October. Moving forward, if the state is going to proceed against my client to trial, these fees, that our retained expert will need will go towards, him having to testify, in our defense. Before, it was the retaining of the expert, so he could create a report to send it over to the state. So I think there is a little difference there. And I will also note, while we are proceeding under the old act, I think given the circumstances of this case, his compliance throughout the process and the new evidence that has come to light, I believe it was the legislator's intent that he be released and there would be no cash bond if we were to proceed under the new act and he not be detained. So I just wanted to clear up that discrepancy with what the state had to say.
But you're not asking to proceed under the new act, right?
At this time, yes, Your Honor.
Okay. Okay, so, well. So I'm going to, grant the motion and I will reduce it to, 10,000, 10% to apply. Now, I show that we have a motion to suppress that needs to be set for hearing.
It's already set, I believe, for July 2nd at 2
We
o'clock.
already said that?
Yes.
Let me make sure I get that. And then this is a 20. July 2nd, at what time?
I believe we especially set it at 2 o'clock because Your Honor may have had another matter at 1.
Oh, okay, I see that, that's here, okay.
Show Judge.
And then are we going to, after that date, be ready to set it for trial?
I guess
It's
it
a
depends.
21 case, so that's my position on that date, depending on what the ruling is on the motion to suppress, we'll set it for trial.
Yes, Judge, that is my understanding.
Okay, thank you.
Thank you, Your Honor.